it's a nice ride. Usually no bottlenecks coming south. Exit 5. Puts you on Main Street.
Main Street.
Yep.
But the others are just nightmares.
I'm sorry to hear that.
No, I mean, the exit. I'm going to call the meeting to order at 5:01, 5:02. I'm going to remind the audience of the expected behavior that we mentioned at the last meeting, that basically that people will behave throughout, be respectful and quiet, and appreciate the seriousness and difficulty of going through a complaint hearing. We're going to briefly summarize what happened at the first half of this meeting, and I've asked Mrs. Temple to do that.
So at that last meeting, we reminded the audience that their only role was to sit quietly during the hearing and not to make any noise or disruption. We outlined the complaint procedure and stressed that the role of the Board of Ethics in complaint hearing is to develop facts and recommendations for the Board of Selectmen. The town attorney Beecher swore in anyone who would testify. Those sworn, the swearing in is still effective today, so we're not going to do it again. You're still under oath. We provided the opportunity for the complainant to present any information he wished, to call witnesses, to provide the opportunity for the respondent to pose questions to the complainant. We provided opportunity for the respondent to provide any information she wished and to call witnesses, provided her with the opportunity for her to pose questions to the complainant. We received 4 exhibits and identified them as A through D. We also received 2 documents reflecting testimony during the hearing. We shared the 4 official exhibits and the 2 additional documents with both parties and the Board of Ethics. We received new information that Dr. Youngblood received advice from Board of Ed attorney prior to her meeting with the BEA president. We requested that the attorney document the advice he provided to Dr. Youngblood. Attorney Beechard offered to be in contact with that attorney and received documents on behalf of the Board of Ethics. We adjourned at 5:26, having completed the opportunities for the complainant and respondent to present additional information and pose questions to each other. We stressed that when we convened to continue the hearing, we would be in the phase of the complaint for the Board of Ethics to deliberate in public. We now enter that phase, which is agenda item 4 in the complaint hearing agenda.
Thank you. And now I'd like to turn to Attorney Beecher. And in the agenda, we've listed continued hearing for the limited purpose of accepting further testimony concerning advice of counsel provided to the Board of Education and its chairperson related to this matter.
Well, my advice would just be that, as we know, up to and including my letter of this morning and Mr. Correa's response, we did not and will not hear any evidence from Attorney Marr. But at this point, because the hearing is left open for the limited purpose of hearing any additional evidence on that, number one, you should give Dr. Youngblood the opportunity to provide any further information she has relative to that specific matter. And then, lastly, as my advice always has been, the respondent gets the last word, and so Dr. Youngblood should also get to summarize and finalize her arguments in this matter before we close.
And we just received that letter today. And we have provided copies to the complainant and the respondent. So I turn to Dr. Youngblood. I'm not sure how to phrase it, but is there anything that you would like to say or comment on from the attorney, from what happened, that you're able to?
Shall I?
Yeah,
Please.
sure. We don't want to get into any confidential stuff.
Exactly. So this appears to be quite sensitive. I guess what I want to start with is to go back to the original complaint This is meant to be about, this hearing, this complaint is meant to be about conflict of interest and recusal procedures. So I don't really understand how we got into the press for attorney-client privilege information about a perfectly legal, procedurally appropriate meeting that the president of the teachers union asked for with me and that I honored. I don't see that they're adjacent, but it's not a causal factor here. So yeah, I don't need anybody's permission to, the board chair does not need anyone's permission to meet with any member of the community, any town figure who says, can we meet? Out of an abundance of caution, knowing to the rigorous scrutiny with which Board of Education actions are reviewed, I did ask the superintendent and the board attorney, like I informed this is my intention. There are no emails about that, these were phone conversations. I shared everything that I learned in this listening meeting with Board of Education members. They met with the attorney in an executive session that I did not attend and declined to release attorney-client privileged information pertinent to this matter.
When did we meet with the attorney? What was the date of that?
I don't know, it might have been June 4th, it might have
I
been.
believe that's correct from the documentation I've seen.
Maybe it was one of the May meetings, but it was not very long ago.
And just another question, how did the attorney find out about that a complaint had been filed? Or, no wait, hold on, it might have been way back. How did you happen to talk to the attorney? Did he initiate it or did you?
Well, we, at that point in the year, and this is, I can't remember if this is September, October, November, December, but we were in constant contact over a variety of issues. But the board had started an uncomfortable precedent about how to respond to complaints brought to the board under the 1312, okay? And so we had an attorney who's no longer working with us, who said, wow, we haven't seen a case like this. This is how we think we should proceed. You know, we should divide it up per policy into two distinct stages. And we did that, and it felt, the board was not, we did not agree that this was the proper procedure based on the particular character of 1312, the policy 1312 that I explained in the last meeting, that it's about district employees, it's not about Board of Education members. So the majority of the board felt like it was not germane. Anyway, so we're trying to talk to, in those fall months, when we were getting 1312 complaints, I was talking to the attorney about, like, are we locked in because of a misstep? Have we established an unbreakable precedent here in how we've responded to these? I can't tell you exactly when we decided to pivot on how we had been dealing with 1312s, but it was around this time.
So just to make it simple for me,
Mm-hmm.
did you talk with the attorney first or did he come to you first?
Oh, no, I'm sure I called him, like, I just got off the phone with the superintendent, and the board chair has asked me the union president has asked me to meet with him. I have open house today, but I have a window of time this afternoon, and he said, you should take somebody with you.
So that was all done on the phone,
Mhm.
right after the union, president reached out to you.
He reached out on an evening, I don't know what day of the week it was, and then I had open house at my school the next day. So I said, like, could we meet in that open window of time? And that's what it worked out.
Are there any other questions?
I have a few more.
Yeah,
We acknowledge that this complaint is about the process of the Board of Ed meeting and not the underlying complaint, but then looking more at the complaint, if it's a valid complaint or not, seems to be relevant. And so I was wondering if you thought that it was, if the 1312 complaint, you know, wasn't appropriate to be brought against a Board of Ed member, then why even hold a vote on it? I guess
Yeah.
that's the crux of the issue for me.
So the way that I think our optics were at that time, not to hold a vote on it would have been poorly perceived, as though we were stifling the opinion, the point of view of a member of the community. If you go back and you watch that November meeting, it was a 4-3 vote about whether or not to take it up. And one of those members who voted to take it up says in the meeting, towards the end of the discussion, I just wanted this to have some airtime. Ultimately, that person voted against moving forward with the complaint. So that's why.
Got it. Okay. So when I was watching that meeting a few times, I was trying to understand what the complaint actually was, and it seemed to me that the substance of the complaint was never actually discussed.
Interesting.
Well, it was a bit, but your view as to whether this was even appropriate, and you were not participating in, you participated in some aspects, but not, my recollection is, but not the full-blown discussion. You had recused yourself. My recollection from your testimony last time was that this is kind of, your elected officials, and you said today, should this 1312 complaint be even brought? Is it appropriate for someone on the Board of Ed? And that view was never surfaced during that discussion, and I'm curious, but you weren't really part of the discussion, so maybe you're not the right person to ask. But it seems like there were other 1312 complaints raised in the fall, and so how come this was never surfaced during these discussions?
I believe that if you review, and I have not gone back and watched each meeting where 1312s were talked about, but I think as this board gained experience and maturity, experience with 1312 complaints, but also with Robert's rules and just better appreciation for group dynamics, I think you start to see a more cohesive pushback about 1312s having to do with actions of board members and saying that this is not right. That's what elections are for. Or the board could take the road of censure or other like intra-board dynamics the wrong word, but finding intra-board solutions. So I can't point to a specific meeting, but as a body, we began to move in that direction. Very clear, my conscience is clear. I'm very clear that I'm not in the wrong.
But if I understand correctly, you weren't at the meeting where the board talked with the attorney about this matter? You did not participate in that meeting?
Correct.
Were you in the room even?
No, I left the premises.
So you're not waiving attorney-client privilege, it's the attorney saying that the board is not waiving it?
There's a member of the board that's
You just said
present.
correct.
Yeah.
There's a member of the board who's
So
present here.
it's not your problem that
Right.
the privilege was waived by the board, it's the board's decision, which they have every right to.
And I'm not sure, I believe that they voted, I think it was 6-0, I'm not sure.
And that doesn't matter to us either. because that's, you weren't participating in that at all, is
Mhm.
what I'm hearing, okay. All right, any other questions?
I think it's important to just go back to the original complaint really quick. You mentioned at the beginning, and that's something that's been on my mind also, is really what the complaint was about.
Mhm.
And I would just love to hear your thoughts on how you feel that you handled yourself at that meeting, right? Do you feel that you fully recused yourself? Do you feel that, you could have taken a different action, or you took the right actions, or, that's what I'd like to hear from you.
Yeah, okay, so, I think, and we're, alright, I'm like locking in on the correct meeting because we've had, multiples of these. So I feel that in the November meeting, was the focus of this complaint, that my actions, to outline the nature of 1312 for people who are viewing it, people who are in attendance and unfamiliar with this process, and then to just kind of put the board members on the same page. I felt that I was correct to review kind of how we got here, which was a review of it was a thought summary. And I indicated that, I would participate up to the, if the vote was to take up the matter, then I would recuse myself. Which I did. I did not physically leave the table. I moved my chair back and refrained from substantive participation. And, I mean, knowing what I know now, if this happens again, we'll move to a different physical location that seems, that is in line with the, phrasing of the code of ethics. I think at that time I felt that my physical recusal was, adequate, and certainly my participation was not substantive from then on until we resumed the meeting, and, so does that answer your question?
Yes,
Peter?
absolutely.
Sure.
I'm sorry.
Mm-hmm. Thank you.
Mhm.
Now it's time for the Board of Ethics to develop facts and, discuss any issues, any concerns that they have, that we've learned from the hearing or from the probable cause investigation. And part of we don't make a decision on this matter, it's not ours to, what we do is we come up with facts, and a summary of what happened, and then make a recommendation to the Board of Selectmen. So we're at that point in the, hearing. I'll just start by saying, the facts of this case are not difficult ones. It's a very narrow, area, and, it's all based on, documented information, primarily through emails or through board meetings, videos, things of that nature. So, we would do more than just focus on the culmination of the facts that led to the issue, that led to, the filing of a complaint about someone not recusing, moving away from the table when a matter was about them. So there were things that led up to it that would have an influence on that. Beginning with, apparently, so I'll start, it begins with really the BEA president emailing the chair of the board for, I guess, to get together to discuss climate concerns at Candlewood Lake Elementary School.
Responding to his initial request.
Yes, and responding to that, that's what set the whole thing in motion. Somehow, the rest of the board found out about the meeting, and I think you mentioned in the hearing, that initial letter or the email from the BEA president might have been shared with everyone on the board.
Mhm.
So it was not a secret, so the whole board knew. And at some point early on, we've received testimony that the board attorney advised that Dr. Youngblood, at least take one other person along with her, to that meeting with the BEA president. And one person was selected, and then apparently one of the board members or someone recommended that someone else also go along on the meeting, but I don't believe that happened. I believe it was just two people. And then, the Board of Ed received a summary or a capsule form of what was discussed at the meeting with the BEA president. I think I have it. Okay, good.
Yeah.
All right, so maybe one of your others, maybe one of you guys would like to handle it.
Can I just interject a couple of things at this point?
Yes.
I just want, for everybody's sake, to understand, we've reached the bright line conclusion of the hearing itself, and now you are in deliberations amongst yourselves, correct?
Yes.
So just, it's amongst yourselves, do not
Okay,
question
great.
the parties at this point, it's done. The second thing, for both the complainant and the respondent, because the hearing's closed, please no more emails to the board, because any email can't be brought up in this proceeding, because this proceeding is now closed as to you and your witnesses. So just keep that in mind, please.
Is that microphone on?
I just recommend you move down. I'm talking as
Well,
loudly as I can.
I'll do it,
Thank you.
I don't know if it's on though.
I
It
don't
probably
know.
isn't.
I
yeah.
stopped by to get the video or audio, but nobody was up there.
I'll speak up.
Okay. Yeah, just come down further. We're not gonna bite. Okay, so we've identified how it started, the meeting on the email of 9/26, the, setting up of the meeting, the talking with the attorney, whether we have documentation for that or not,
And whether it's reliable or not.
Right, and whether it's
Is one of
reliable or
the
not.
things we have to determine.
yeah. The odd thing is it really, it doesn't really affect our deliberations. What it would do, would be, a documentation that Dr. Youngblood did what was recommended to her by the attorney. But if we don't have that documentation, it still doesn't really affect what we do here. It just validates a decision that she made. That's all it does. Anyway, so whether the attorney gave the advice or not, okay, just a bit of information. And then we found that a day later, maybe 2 days later, Dr. Youngblood provided a summary to the entire board on what happened at the meeting. So now I'd just like to mention, on October 30th, we learned that there was a workshop provided to the board by attorney Tom Mooney, who is an expert in school law and school matters, and is an attorney with the Shipman and Goodwin office in Hartford. And it was an excellent, really excellent workshop. He talked about everybody on the board and everybody involved in a school has to keep in their own lane. That you have certain people who make policies, and that's the Board of Ed, and they also do budget, and rarely but often, sometimes get involved with judicial matters, probably like expulsions of students. But that the Board of Ed's lane is policy and budget primarily. That the superintendent is the executive who carries out the policies, not the Board of Ed, regarding policies related to the schools. It's the job of the superintendent, and the superintendent also gets involved in judicial matters. And he kept mentioning at that workshop, stay in your own lane, and it's very true. And that's, you get into trouble when you get out of your own lane, which I think is what happened here. And I think that's how we got to the actual hearing. and the misunderstanding of the role of the Board of Ed at the hearing, that, we can go through it, and I'd like to go through all the different bylaws, but, many bylaws really weren't followed, and that really led to this whole mess. And I don't think, I never really got the sense that there was anything consciously, you know, like someone trying to push an agenda, assuming too much authority. I really think it was,
Well-intentioned.
well-intentioned, absolutely, that, and this is, an occupational hazard of teachers, that they wanna help, and they wanna solve problems, and they want things to go smoothly, and that's essentially what they do all the time, so, I think that's how some of the misunderstanding of a role at the hearing on November 20th, I think that's how it all came about. And
Yes, but that's, I mean, that's the right background, I think, and then the only thing that we are to adjudicate on or
The hearing.
is the actual November 20 hearing.
Yes. Go ahead. Take it away, whatever you'd like to say.
There were several, instances during that hearing where Dr. Youngblood did recuse herself, but not fully, and was at the table, and which is contrary to the wording of the statute. And so, I mean, it just, I could see that you were trying to comply and didn't fully do it. And so that's really my thought there.
Anything?
That's actually why I wanted to hear from Dr. Youngblood. I felt the same way. I felt that there was an action to recuse, but it was not fully. And, it was pulling back from the table instead of leaving the table. And the actions of meeting with, Dr. Petrino, was it, or, I feel like that was something that's sort of like, kind of, being discussed, but not necessarily really like what the complaint was about. I really do think it was, Dr. Youngblood pulled back from the table, but there was discussion, and, and there was continued discussion. It was, recusal but not fully. So.
Do you have any other facts that you care to offer? Cause this.
I watched
I don't
the
have the
video a
exact
few times.
times and facts right now, of like
No,
what the votes
What
were
types
and
of
what-
facts are you looking for?
No, I'm just looking for if there's any pertinent information, that we have, and as I say, there's not a lot of things in doubt here. It's actually a very simple, straightforward complaint, that's been made, so it's, I think we've covered what it was about and how it all came about, so.
Sure.
So the logical thing now is to see, do any of the bylaws apply from the Board of Ed?
I think they do, but that's not, that's regarding her engagement with Mr. Petrino.
Well, actually, if the Board of Ed had actually talked about the bylaws, I don't think we'd be here today. If they had cited what it was that was concerning them during the actual meeting, I don't think we'd be here. I think the matter could have been straightened out at that level, but it didn't, so here we are.
So there was a dysfunctional communication on the Board of Education.
It was, Christina said, they never actually got to the heart of the matter of what it was they were concerned about. It was only whether an issue was raised and should that person immediately move away from the board, and not participate at all unless asked. But if they had actually handled the bigger issue, then we would not be here,
Scholarship?
yeah?
Yeah.
I can go through what I came up with. I looked at policy, 9211, bylaw 9211, this is on the Board of Ed side, which talks about a 2/3 vote of the whole board that you could remove an officer from office. And on the Board of Ed, the board members determine who the officers are and how long they stay as officers. And so there were attempts to remove Dr. Youngblood, but the issue never was brought up. It was just, let's get her off, she can't be president. And so there really wasn't a conscious discussion of why, even though I can understand it. I'll just continue. I looked at bylaw 1312, which is the Board of Ed's bylaw concerning community relations and members who have a complaint about something that went on in the schools. And the complaint shows a chain of command that begins with the resolution at the lowest possible level with an administrator, well, probably with a teacher first, and then the administrator, and then the superintendent. All along the way, people are trying to resolve the complaint, and if that doesn't work, then the actual complaint goes to the Board of Ed. And so the complaint really isn't about members of the Board of Ed, it's really about employees of the school system, as far as I can
So,
read it, because there's no.
I think also that's what Ms. Youngblood was saying, is that if you're referring to the 1312 provision, maybe that's not appropriate. Then the board of selectmen should think about whether it should be applicable to the Board of Ed.
That, and the other part is if there are concerns about actions of board members, there are some mechanisms for the board, and it's that policy that we just talked about, 9211, which probably would have been more appropriate to bring up the specific issues that caused all of this to begin with. Now, the problem is, once the censure motion failed on November 20th, I didn't hear any other discussion about the meeting with the BEA, with any of that. It just was gone, and the board seems to have moved on to other matters, never really, I don't think, understanding their roles as board members. I don't think they fully realize their important roles in this matter. So I actually see this whole complaint as a huge learning experience for everyone involved. Definitely for Dr. Youngblood, and definitely for the board members, all of them. I can mention some other things. Okay, I'll do. The general duties of the board, policy 9000, the board represents the community in carrying out general policy to be employed in the conduct of schools. And in determining the policy, the board authorizes the superintendent to carry out its policy. The superintendent was never mentioned in any of this, what role, if any, the superintendent played in trying to resolve whatever the concerns were that caused this whole issue. Limits of authority is the next one, policy 9010A, and this one is huge. And it says, because all powers of the Board of Education lie in its action as a committee of the whole, individual board members exercise their authority over district affairs only as they vote to take action at a legal meeting of the board. That's huge. Board members do not act as individuals. The policy goes on to say an individual board member, including the chairperson, shall have power only when the board by vote has delegated authority to him or her. And that didn't happen here before the meeting, and that should have happened. it gets messy, it gets tedious, it gets hard to schedule, and we run into this all the time on the Board of Ethics. It's very frustrating, everything you do has to be run past everybody else because we're a group of the whole. The Board of, the Board of Ed has a code of ethics, policy 9251, and it says that board members adhere to the principle that they shall confine the board's role to policy making, planning, and appraisal, while the superintendent shall implement the board's policies. In this matter, if there's a concern with teachers and climate and whatever their issues are, that has to go through the process to the administrator, to the superintendent, and then to the board if the superintendent can't solve it. It should not go directly to the board because you're just ruining the entire underpinning of the bylaws.
So it sounds like that maybe they need, education or
Yes.
a way to work together
Yes,
to help them function better.
yes. Definitely, that would be one of the recommendations that we would make, that I would make and encourage the Board of Selectmen to endorse is, they really do need, assistance in learning how to work as a board. Resolving issues, as single members of a whole body and not as groups within the body.
Okay.
So that's one recommendation I would strongly make. And I'm sure like CABE or other Connecticut Association of Boards of Ed, if they're members of that, would have workshops. And it would be a very useful thing.
I think it's also important to note, I mean, something that Ms. Youngblood said last time stuck with me is that this 1312 complaint situation can be really weaponized to skew, used by a small group of people, could really undermine the democratic process. And so I think the Board of Selectmen should take a look and see whether the 1312 complaint process is appropriate for situations like
Board of
this.
Selectmen or Board of Ed?
Board of Ed.
Should look at it?
Board of
Could the
Ed.
Board of Ed look at it
Oh,
and not the
yes.
Well, their
Selectmen? Cause I thought we were
recommendation.
recommending
Oh,
to
yeah.
the Board of Selectmen.
Well, yeah, but that part of your recommendation would be for the Board of Ed
Great.
to do that.
Okay,
So
Board of Ed.
I truly think the Board of Ed should take a
Okay.
look at all the bylaws. I mean, I would even get so narrow as to recommend at every board meeting, talk about one of the bylaws so that everybody, you don't have that many, and eventually every board member would become familiar with what they are, Board of Ed members. But so definitely to look at the 1312 and who it applies to.
yeah,
Let's see. I do think that, they should take advantage of CABE and the different workshops that are offered there, not only, to have somebody come down here, and present a workshop, but also, to kind of network and find out how other boards function and, how meetings are held and what happens when, there seem to be smaller factions pushing a specific agenda. Just, when you're new on a board or when you don't serve on a lot of boards or you're not used to it, it's very hard to
yeah.
all of a sudden not get all upset about things that shouldn't be upsetting to begin with, but you do get upset because you think your integrity or your comments are being avoided. It's just learning how to work as a board. I think that's just strongly needed.
agreed.
Yeah.
Anything else?
Now, my other recommendation, would be that, the Board of Selectmen should consider a reprimand, to Dr. Youngblood. And it's really for, overstepping her authority.
Well, if she was given authority by, or if her actions were sanctioned by the board's counsel,
See, that's the big thing.
I don't know if I would vote for that.
I like to hear that. That's what we were really trying to determine, with the comments by the board's attorney. Did the board attorney mention anything about that's not your role? And if it didn't, then Dr. Youngblood would be able to infer that taking someone along would satisfy whatever issues might arise out of meeting with an individual to discuss a board matter. Like, board members can meet with anyone they want on their own as ordinary citizens, but not as representatives of a board. You just can't.
I think the bylaws make that clear.
Okay, so the bylaws will do that. So it looks like then, we're not recommending a lot. We're recommending workshops from CAVE. We're recommending, specifically start looking at all your board policies, bylaws, I'm sorry, I keep getting them mixed up. All board bylaws, especially 1312. Consider going to CAVE workshops and learn from this.
Yeah, and I think that it seems like maybe it's an even larger issue where, the folks at the school level need to understand the bylaws
Yes.
as well as the attorney needs to know the bylaws, so if there's any advice being given, it's with good education, the superintendent should be aware of the bylaws, so I think there's sort of this overarching education piece that has to happen across the board.
Anything that we've missed here? Anything we've missed, anything else we should add?
I don't think so.
Are you going to draft a report to the
Yes.
Board of Selectmen and come back and actually finalize things in
Yes.
the meeting?
Yes, we are.
That's a great idea.
We're gonna, we'll put, alright, so these are our rough thoughts that we will incorporate into a report. And the report will be to the Board of Selectmen, but here's a matter where not one person does this and just sends it out. We put the draft together, everybody looks at it, and then we vote on it in public and it gets sent out, so. Those are the essential issues that we'll be looking at and putting it together. Do we have a time limit on this? Okay, good, there's not a time limit, so,
Do you wanna pick a date?
yeah, we'll set up the next meeting. Do you want to draft it or do you want me to?
I can draft it.
Alright, so,
And bring it with me.
Mrs. Temple will draft, our report to the Board of Selectmen, and it's not an enormous report, it's, normally a 2-pager kind of thing. We usually attach our probable cause findings, so that the Board of Selectmen have some idea of what the background was. And then we attach this report, and so it looks like it's mostly gonna be to give guidance to the Board of Ed to, learn how to function effectively as a board. Everybody.
You wanna pick a date?
Yes, we're gonna pick a date. And when we get together, this'll be primarily, to handle this report, and then there might be other board stuff that we'll handle, but that's where the report will get.
Just one final point.
Uh-oh.
Now that you've completed the hearing, on this matter, where everything got fleshed out. I just wanna remind the board that you are therefore not married to what you put forth in your probable cause report, because your thoughts and the facts that you fleshed out may be different. So just keep that in mind.
Oh, that's a good point.
We heard evidence after we issued the report.
Correct.
Okay. So we wouldn't have to attach that? Or we
Well,
did-
you can.
We
but-
already gave it
but,
to
I mean,
the, Board of Selectmen.
But our understandings have evolved.
Yeah.
If, to the extent that
Yeah.
we need to change them, we will.
right.
Okay. Okay. So we'll set a time, how soon can you do this?
Are we talking later this week?
No.
Is that,
Okay.
okay.
Next week, I'm guessing next week?
Next week and the following week are not possible for me, but the week of the 14th are, I have availability.
Yeah, we're running into, July 4th and all that stuff.
Yes.
That week is fine, the 14th.
The 14th?
Mm-hmm.
Okay. Do you wanna do it on a Monday?
Sure.
Okay, Monday, 14th.
I'll be on vacation, but I don't know that you need me.
I
this
would
week.
We'll miss you. All right,
Is
so,
5:30 better for you?
Yes.
Monday the 14th, and a primary, agenda item will be to be finalizing or attempting to finalize our facts and summary and the recommendations to the Board of Selectmen. But what you've heard today is essentially, I think, our conclusions.
Yes. I don't think there will be a surprise. So can we do 5:30 on July 14th?
Yeah, yes, there's all these things that are down here, there's a meeting coming in right after us, so we'd have to be out in an hour.
We will.
Okay, good. Okay.
Alright.
Okay, no other matters? Motion to adjourn,
Second.
any discussions? No. We are adjourned at 5:55. Put all these back up again.
I'm gonna roll my dad out of here.
Here's another copy for you.
Christina.
Thank you. See you later. Sorry.